All right, let's get started. Our first panel is a great panel, ransomware attacks, what to do when you get the call. And we have a fantastic group of panelists here. Let me start by introducing Dan Pepper, a partner at Norton Rose who advises clients on proactive data privacy and security practices, data breach incident response, and regulatory compliance, has more than 25 years of experience. Dan was previously a senior in-house counsel at multiple multinational telecommunications conglomerates and is joining us today from New York. Welcome, Dan.
Hi, everybody. Thanks, Bruce.
Very pleased to introduce Jamie Singer, a managing director at FTI Consulting, where she co-leads the firm's cybersecurity and data privacy communications practice. Jamie has counseled Fortune 500 companies and public sector organizations through some of the most high-profile and largest cybersecurity crises of the past decade in the healthcare, financial services, technology, airlines, and other sectors. Jamie's joining us today from Chicago. Thanks so much, Jamie. Welcome.
Thanks, Bruce.
Very pleased to welcome Heather Sussman. She's a partner at Orrick and head of that firm's global cyber, privacy, and data innovation group. Her practice focuses on privacy and cybersecurity information management, and she's known for being able to expertly guide her clients through the patchwork of the many laws impacting privacy and cybersecurity in the U.S. and around the globe. Joining us today from Boston, welcome, Heather.
Thanks, Bruce. Bruce, it's great to be here. Appreciate you having us.
Thank you. Finally, delighted to welcome back Kim Peretti, a partner at Alston and Bird and co-chair of that firm's cybersecurity preparedness and response team and the National Security and Digital Crimes team. Kim is the former director of PwC's Cyber Forensics Group and a former senior litigator in the DOJ's Computer Crime and Intellectual Property section. And she is a certified information systems security professional and joining us today from DC. Kim, great to see you. Welcome.
Thanks, Bruce. It's great to be back.
All right, Kim, it's all yours.
Okay, super. Well, really excited about this panel. I think it's a great panel to kick off the forum because as you've seen the title, it's what do you do when you get the call? And we wanted to set up a framework. Those calls come in anytime, right? Any time of the day, night, weekends, vacations, and you have a panicked client on the phone who's experiencing a significant event at their company, and they need help to navigate what issues, how to think, how to prioritize, what needs to be done first. And a lot needs to occur in short order. So what we thought we would do today is organize around 6 topics that could arise on that first call and how to work through those topics, how to think through those topics, and then how to prioritize. We also want to cover at the end sort of lessons learned, what we've seen worked well in the first 24, 48 hours, and then maybe pitfalls or challenges, because getting it right in those first 24, 48, 72 hours is very important for mitigating the risk throughout the response process. So the first topic we have is on containment and kicking off the investigation. So the call comes in, the client is experiencing ransomware, hearing from their IT group, it's spreading throughout the environment. There's folks taking steps to restore, recover, rebuild systems immediately. And the client asks you, what should you be doing? And should you investigate? And of course, we hear often from them, well, this is just, an IT thing we need to deal with on the rebuilding or restoring side. So why would we need to conduct an investigation? Dan, I'm going to turn it over to you to kick off that topic.
Thanks, Kim. Yeah, this is a really common situation that we see very frequently. And, for good reason, right? Most organizations that experience ransomware, this is, presumably the worst day in their professional lives. The thought and the fear of extended downtime with the associated loss of revenue, loss of just business operations is a frightening perspective. And so quite understandably, many organizations want to move directly to a recovery and a restoration mode right away. And, there's really no established formula at the end of the day that dictates when the goals of preservation or restoration to take precedence over moving into a forensic investigation first. Because certainly, as I mentioned, the continued downtime for the company is likely going to be their biggest expense associated with the ransomware incident. The challenge is that any sort of wholesale system restoration is going to make it difficult or impossible for any forensic investigators to determine the root cause of the security incident or the ransomware, identify any security vulnerabilities that may need to be remedied, and to the extent that there's compromise to data on the systems, by moving directly to restoration and not getting the evidence and information from a forensic investigation to determine that kind of compromise. Legal obligations that a company may have with respect to data that may have been compromised or accessed may not be able to be determined. So it's a balancing act that's not always an easy one, but typically what we like to do in that first initial 24 hours is to get a sense of, what systems have been impacted. What is the actual impact to the company? Do we have certain systems that contain sensitive data that may be exposed here that we need to investigate a little further? So those are some of the considerations that we'll discuss, and work with the company to have them really have all the information that they need to make an informed decision about moving directly to restoration.
Well, and I think what's important is that, companies haven't often been through this. Hopefully they've never been through it before. And they may think they know the steps that they are taking are the most important, effective to contain the ransomware or to restore systems. But if you bring an investigator, they often have, and they've been through this many times and can provide guidance, very quick guidance to the company on steps to follow to help the process and join the investigation and the restoration work stream. Heather, any thoughts on that?
I think this is crisis mode, right? And so you're in a crisis management mode. And if any one person, whether at the business or outside counsel, in what I do, any one person thinks that they're going to be able to manage this crisis, it's just not going to happen. This needs to be a team approach where everyone identifies your swim lanes and has their specific responsibility. And then there has to be good coordination and communication among those groups. That's why we talk a lot about preparation. You're going to hear, the audience will hear about that a lot today, preparation through tabletop exercise, practicing these things. But once you get that call, it's deploying the teams. And so typically what we're doing is setting up, okay, here are the different swim lanes. We've got the investigation to kick off. We have containment. We have recovery, restoration. There's a whole comms work stream. You're going to hear from Jamie later today about the importance of comms. And I think my experience has been that communications issues in a ransomware event in particular end up being what drives so much of what we do, whether that's communication with a ransom negotiator and retaining that individual, or communication with regulators and working with regulators. But if one person tries to do all that, there just aren't enough minutes in the day, and all of these things are happening in a dynamic way. So breaking it down into those manageable work streams, assigning someone both outside counsel, in-house counsel, and business teams to be responsible for each of those swim lanes, and then ensuring each day that you're setting up a morning call, an afternoon call for purposes of coordination, feeding all of those facts and the information coming out of the investigation, just as Dan said. You're going to follow the data, right? You're going to follow the threat actor, try to find what systems were compromised, what evidence do you have, all for purposes of feeding into your other work streams. So that I'll pause there because I know my fellow panelists have a lot to add.
It's a great structure, right? I mean, the structure is very important. Jamie, anything to add on the initial containment, kicking off the investigation that you've seen with your working through these issues with your clients?
Well, I would agree with Heather. The importance of getting into clear, distinct work streams right away is critical. So everyone is not trying to do everything. And also to agree with Heather, making sure communications has a seat at the table early on when the investigation is kicking off, containment, restoration, because our communications response is only as good as the facts of what we're doing. And so having insight to that early on is really critical.
One other piece of analysis I think it's really important at this stage as well is identifying who we're dealing with by way of the threat actor, right? Because most ransomware actors will proactively advertise their existence, right? Typically, they're going to leave some sort of a pop-up message or decryption instructions placed in the same directory as the encrypted files. It's really important, even if an organization is moving very quickly to restoration, to save or screenshot those instructions or that pop-up note from the threat actor before any of those remediation efforts start. Why is that important? Getting that preliminary attribution based upon the file extensions that are appended on the encrypted files or the content that appears in the note gives us the ability to start an analysis of whether this is a threat actor that's known to only encrypt, or maybe they both steal data and encrypt information. Is this a threat actor that might be on a sanctions list, such that we may not even be able to communicate with this threat actor for fear of sanctions? Or they affiliated with a group that's on the SDN list or operating in a sanctioned country. That kind of information can be gleaned relatively quickly. So even for organizations that want to move to restoration fast, this is critical information so that later on, if it determines that, hey, we may need to communicate with a threat actor, which we'll talk about in a little while, we've just gained a lot more information that can help inform those conversations.
And then Kimberly, we don't have forensics on today, but you, with your technical background in CISSP, it's I think a really interesting perspective. I'd love to hear from you, because one of the things that we hear often is that, okay, just immediately start disconnecting systems from the internet, right? You want to disconnect your affected systems from other portions of the network, trying to contain and cauterize. I'd be curious to hear your perspective because I know in some cases that could actually be the wrong move. And so how do you decide and prioritize stop the bleeding?
It's a great question, because we are more comfortable generally as outside counsel in directing forensic investigations and working with our partners on how to collect, preserve the evidence, the digital evidence, how to review it, how to, understand what's happening. But when you come into the ransomware incidents, usually it's been 12 or 24 hours where an entire team has been taking some steps already, and you're really playing catch up to understand what they did. And sometimes you always find out aftermath that often more happened than you even become aware of immediately when you get the phone call. But that's really where it's challenging, because you want to insert yourself, but at the same time, you have individuals there that know the systems, they've done the backup plans, the restoration, the BC, the business continuity and disaster recovery plans. So you have a lot of steps that are being taken. And in some ways, you don't want to stop that either, because stopping that can mean that the ransomware hits more systems. So I think it's a really delicate balance to sort of depend on the existing resources and expertise of the company and just start understanding what they're doing, but certainly telling them not necessarily to shut things down. I think that's the one piece of advice that you can say early on. Don't shut it down. You can disconnect it from the network, but if you shut it down, you can lose memory and then it's gone. And we've certainly had that happen in many cases. But also the ransomware might be on 200 systems, right? And the question is, can we quarantine it? Can we remove it? Do we need, images of 200 systems? No, usually you just need forensics on the script that was run to put the ransomware on systems. And then you want some sample. But if you come in and say, whoa, don't take any steps on 200 systems, that's really not in the best interest in the client. So I think that's a really hard place, is the restoration of what's happening from the IT folks, from the engineers, to understand it and then know how to counsel through that.
And what I really liked hearing from Dan too about retaining the outside, the forensic investigator too, is that most law firms have a number of relationships already on retainer. I know that when I get the call, I'm typically immediately texting with just to figure out who's available, who has the capacity to take a new matter on, and we're trying to quickly onboard. All of our purposes of having that forensic technical capability to be able to do exactly what you just said, Kim. Let's get on the phone and let's start brainstorming. What other things can we be doing? Should we be doing? Let's focus on preserving evidence, focusing on doing what we need to be doing to investigate what it is that occurred.
Well, and there's a whole new work stream around this operational considerations and the strategies for recovery, the restoration, right? It's hard to say, go look at your, business continuity disaster recovery plan. Hopefully they have one. I think where we can really counsel is on the expectation of the whole process. Because usually when you've done the test in advance, you'll have someone who represents that work stream, part of your ransomware preparedness activities, and they'll say, look, we can restore our data in our systems in 48 hours or 4 days or whatever. But what they don't build in is then ransomware, you're not just immediately able to restore, because you have to go through a testing process to make sure the system's clean. And that often isn't accounted for in the process. So what we can do is help them understand the expectations of, if you don't pay, you think you have backups, you think you can restore your systems. It really isn't just so easy as when you do the planning and other system outages. I think that's a really big, important point. And the second thing I'd bring up, like we're used to working with forensic firms, now we have all these recovery firms. And the insurance carriers are pushing those recovery firms because they can significantly decrease the time it takes to do the recovery. It's really hard to sort of work that in because all companies are like, my systems, we're going to restore them, we can do it. I've got a team of people. But what they, often are not aware of is just the resource drain. It's an incredible resource drain. These ransomware attacks can be prolific, many systems involved, and within a couple days, it's happening over holidays and weekends, really getting that staff augmentation, getting a different team in who can surgically, help deploy the forensic tools, help rebuild, help restore, bringing in, there's just like there system engineers, whatever skill set you need, there are these recovery firms that really help through the process and can help the company minimize the losses at the end of the day.
Those are great points, because one of the things that we see is, I hear you, they'll say, oh, we can be back, we're back up in 48 hours. Okay, but on a ransomware attack, you can have software, middleware, firmware, hardware, right? Like all these different things that can be impacted and all this interconnectivity of systems. And if you ask them, have you ever tested a restore? Have you ever tested a system-wide restore? Like there's the layers of complexity that go into that just can further delay the process. Not that that suggests that you should go out and buy a key, right? That you should pay the ransom in order to get the key, because restoring, it's actually typically faster to restore systems from your own backups internally than to do it, by key. All of that said, no question that there's a misperception, especially for lawyers and for the chief privacy officers out there, for the business teams out there, to say, you may ask your teams, oh yeah, we can be back up around in 48 hours. Start to unpack that. What does that mean? And so if we haven't prepared by testing and tabletopping these potential, the complexity of it, then we should.
And here's another aspect, and then we can move to comms, but it's not, the company also needs to rely often on the vendors and the SaaS applications and others outside their organization to understand what to do. And sometimes that hasn't been accounted for. That takes time. And then, of course, from a privilege standpoint, we often find out about that later, but guiding the company through rules of the road of who needs to be engaged under privilege, who you can contact that's an external software provider or otherwise without privilege, but just make sure you don't share details of the privilege investigation, right? I'm sure you've all experienced that as well. Dan, I cut you off, I think.
No, I was just going to say, excellent points, Kim and Heather. The one point I was going to make when we're talking about these initial stages with restoration is identifying, whether the backups are viable. Are they complete? Are they unaffected by the ransomware? Yeah. Threat actors have gotten really good, as many of us know, about finding where these backups are, whether they're local, whether they're hosted, and the assumption that those are intact and moving directly to restoration, may just be buying yourself, another encryption event right after you restore. So something to think about too in those critical, frenetic, first 24, 48 hours.
Because you never want to find out 2 weeks later that a critical backup with the data that you need, there was a gap of 3 days, right? And you need that data, and then the criminals might be off and you're not able to negotiate to get the decryptor tool. So good to know that and really press the client to identify those issues sooner rather than later.
I would say too, Kimberly, don't forget about third-party connections, because you could take all those steps that we just described and go through the process of containment, bring in your forensic investigator. But if part of your third parties, you're bringing in one of those recovery providers, or you bring in one of your already known, service providers who's otherwise been outside the system, but their systems are actually affected and they don't yet know it, they can reintroduce the malware, the problem, by reconnecting. So just being meticulous about how you're treating the environment within which you're working I think is
Yeah, that's fabulous. And it reminded me how often the company believes they know how to restore properly and turn the system back on. And then the malware is still there dormant and kicks off a whole nother ransomware cycle. So all good to make sure the investigation side, the restoration side are working together. Now let's turn it, usually right in that first call is communications issues, right? Various stakeholders are aware of what's going on. And Jamie, how do we approach comms? What should we be doing and thinking about in those first 24, 48 hours?
Yeah. So, often with ransomware, with encryption, there is an immediate communications imperative because there is some sort of operational disruption that employees, customers, and other stakeholders are experiencing. And, what I would say is one of the more overlooked aspects of communications in those first 48 hours is the internal comms piece. Yeah. And it's critical because employees essentially wear two hats. They are likely impacted by this ransomware incident in terms of their ability to work. And at the same time, they're the face of the organization to customers. And so they need to know what to say and, more importantly, what not to say. And in our experience, if the company is not communicating directly with employees, that's when they go to media. That's their frustration is taken out through those anonymous quotes that we often hate to see. So those first 24 hours, critical to say something to employees, what the workarounds are, what we want them to say or not to say to customers. Those escalation paths are critical. They're also going to have concerns about, can the company make payroll in this time? Was my data impacted? And this is where it's so challenging because you don't want to get ahead of the pace of the forensic investigation and give out information that's speculative or going to change. So it's certainly a balancing act with employees. And then the customer communications aspect has become an extremely challenging piece, I would say, especially for B2B customers and service providers, because in those first 24, 48 hours, their customers are going to be inundating them with questions. Is it safe to reconnect? What's going on with restoration? Is my data impacted? Do I have notification requirements? So it's important to say something to customers, but then you have to think, do we do a whole blast email to every customer? Which there's pros and cons of that. Limiting it to your top customers, again, pros and cons. So a lot of considerations. And then it's about managing the income. Having a system in place for managing all the inquiries, the requests for indicators of compromise, the request to fill out security questionnaires. This customer wants to talk directly to our CISO. How do communicators protect the security teams who are focused on recovery and remediation while answering these very difficult incoming customer questions? So really important to have, those systems in place. And then obviously the interplay between comms and legal is so important. And so would love to hear my co-panelists' thoughts on sort of, those communications considerations in those first 48 hours.
Yeah. Jamie, I have a question for you. So often we'll work with clients who are hit by ransomware, and their immediate reaction is to go out, be public, be transparent. They feel as if they've got an obligation and a responsibility to let everybody know what's happening. They don't want to hide the ball. They'll indicate, look, we see data breaches in the news every day. That seems to be the norm, to get out and talk about it. Obviously, there's some considerations and issues with that. How do you typically advise clients who want to go very quickly and push for that kind of transparency?
It's a great question, because I would say every client I've ever worked with on the first call says, just so you know, we have a very transparent communications culture, which is great. But this is where ransomware is different, I would say, than most other types of crises, because going out broadly, proactively right away can actually create more risk. Again, because the facts are going to be so fluid. We're not going to have a lot of information to say. In my experience, it's rare that companies will get a lot of kudos for going out early. And it's better to go out with as much complete fact set as possible. At the same time, again, you need to say something to critical stakeholders, but media is not your most critical stakeholder in this moment. It's your staff, it's your customers. So saying enough that we're giving some information, but not, again, getting ahead of the facts and putting out information that we're later going to have to correct.
And how, though, if you provide a communication to all your employees, isn't it essentially anticipated it's going to get out? Is it perhaps preferred to just identify the impacted employees that have their job functions impacted and keep it narrow, initially?
Ideally, yes. I think the challenge, right, is we've been in many client situations where employees are seeing the ransom note on their computer, or I've had several healthcare clients where the ransom note is being printed out through the printers in hospitals. And so sometimes it's hard to hide the ball, with staff. But yes, as much as we can limit it, the better. But also, if we're writing those employee communications, every time we write them, we are expecting that they will leak. So we want to put information in there that we are comfortable seeing in the headline of a newspaper article.
I actually think, oh, sorry, go ahead, Kim.
No, go ahead.
I think too, we're talking about internal communications, external communications, having those be two distinct work streams, because the issues it's going to happen so quickly, but close coordination, because consistency is so key in the messaging. And that's where I think working out well in advance of a ransomware incident or any cybersecurity crisis event, what are your holding statements? Picking your 3 to 5 most likely to face kind of incidents, and then developing your full communications playbook for each of those, so that you have worked out in advance some of those just cultural nuances. Like, okay, what if everybody knows about it? Here's what we're going to say. What if it's just selected people? Okay, here's what we're going to say. It's also the same reason that we no longer do a tabletop exercise, right? Just one tabletop exercise that includes interspersed communications issues. We typically recommend that you break it out and we do a series of tabletop exercises where comms is one specific exercise. So maybe you have your first one is the incident response team, and you introduce the scenario. You put a pin in all the comms issues, because otherwise comms so quickly derails the tabletop exercise. My experience is that it becomes less meaningful and it's hard to get through that first exercise. So if you put a pin in it, your next, maybe 2 weeks later, 4 weeks later, whatever it is, you reintroduce the scenario, and then you focus very intently on the comms issues. Maybe it's a slightly different team than who you had in the incident response portion of the tabletop, but it's real life, right? Because there are different teams that are participating in each of those work streams that I described earlier. And then there are other modules along the way that you can do for those tabletop exercises to really get you at a point where you're better prepared if and when one occurs.
And fantastic points. Before we turn it to Heather on the regulatory side, Jamie, one last question for you. So earlier on in the ransomware attacks, the first communication often put out is there's been a technical outage, a service outage. Is that still the preferred way to have an initial communication, or is it just anticipated that you might as well skip to the actual, this is a cybersecurity incident, because you might have to say that soon? What is the preferred initial communication?
It's a great question. It's where the majority of my clients get stuck, those first 24 to 48 hours. So I'd say a couple things. One is the word ransomware is not as much of a dirty word today as it was a few years ago, right? Because it is so common. So I do think it's less of a landmine. However, in the minute you say ransomware, you will get those very difficult questions. How much was the ransom amount? Are you going to pay? Why or why not? Does this mean you've had a data breach? So it is difficult. Our advice typically is not necessarily day one to go immediately to ransomware, because again, we're not going to have a lot of information. But at the same time, the network outage language or IT outage language after those first 48 hours is going to be looked at with distrust among your stakeholders if you're going to be down for a while. So we look at it sort of an evolution. Those first 24, 48 hours, not alarming stakeholders, but then quickly as we get throughout the investigation, being able to acknowledge, we've determined this was due to a cybersecurity incident or ransomware incident. Here's what we know. Here's what we're doing moving forward.
Right. And communications are all about getting the trust out to the customers and stakeholders, right? So good point. So Heather, in the first call, there's always a counsel or a general counsel saying, okay, this is great. I know what my IT folks and my security folks are doing, but do I need to tell anyone from a legal perspective? Do I have any disclosure or notification obligations, and how do you counsel them through that?
So there's the potential to have regulatory notice obligations, contractual notice obligations, and then the potential for voluntary notifications. We can talk a little bit depending on the transparent culture of the particular company. But let's talk through each of those, because whether you have a regulatory notice obligation typically flows from the type of incident, the type of data that's impacted, the geographic region, and the industry, right? Because maybe it's a heavily regulated industry where critical infrastructure, for example, it's going to be a very different regime than a consumer products company that falls outside critical infrastructure. And type of data, right? Typically a ransomware attack, and it depends on the variant that you're working with, the threat group. This is you're going to hear a little bit about hiring a ransom negotiator. And so one of the benefits can be gathering intel about the threat group to better understand their MO. Did they take data? Did they claim to take, or did they insist they didn't take data? And so whether or not there's been a personal data breach, a breach of security, it's called something different under every different regulatory regime, but identifying, typically most laws don't require notification over the fact of a ransomware attack. You're typically looking to determine whether there was unauthorized access or acquisition of personal information, personal data. Again, it depends on what geographic region you reside in. There is a handful of jurisdictions around the world, and again, in some of our more heavily regulated industries, that do treat just the fact of a ransomware event to be notifiable. And so if you are in a heavily regulated industry, or if you're operating around the world in some of those higher risk jurisdictions, and we keep a list internally as to what they are that trigger a notice obligation based purely just on the fact of a ransomware. I mean, if you have those obligations, then typically you have them, and you're lining up your notices accordingly. Can
I just ask, is it the fact of the ransomware, or is there a materiality component to it for some of the statutes? And then you have to work through that as well.
So materiality is a component in some jurisdictions, but in others, like South Korea, for example, if you're in a particularly regulated vertical, then you're going to be notifying based on ransomware within the first, in a matter of hours. We also have in India, for example, has new rules and requirements. There's just, it depends on where you're operating. But if we're talking about here in the United States, then we also see public companies, right? So you've got the potential that you're evaluating materiality in the public company context as to whether this is going to be a material disruption of your systems and trigger a reporting obligation pursuant to your public company requirements. And those are the new proposed rules with the 4-day requirement. What we are seeing is more companies acknowledging that this is the expectation of the commission. And so they're making notifications within a very short time period, even if they say in the disclosure, we don't think this incident is material, but it's sort of like, we don't want to get in any kind of regulatory hot water. So we're announcing this publicly. And those are all considerations that we are typically, well, I'm not a securities lawyer, so I'm working hand in hand with the securities team to make those kinds of determinations and evaluations. But it's a very tight timeline. And that's why I think you have to be close to the facts and know, are we talking, tell me about the data, was data impacted? Tell me about the systems. Let's understand the industry and the different verticals and the geographic region in which you're operating and where the ransomware proliferated. And it's once you have that web and understanding, that's when you can start to tease out the potential regulatory waterfall.
Great. Fantastic. Lots to consider there, right? Usually you get a little bit of a breather from making an immediate notice, but lots to consider and work through in the first 24, 48 hours. So, and
I would say in the first 24, 48 hours, you're typically not making those regulatory notifications, right? Because you need to take that breath. You need to really make sure you understand and have a handle on what the facts are. And it's a bumping up against that timeline, of course, but working closely with comms, because you're going to want to make sure any message to regulators can be consistent with the rest of your messaging work stream. I talked a little bit about regulatory notices. There's also contractual notifications. My experience is that, again, depending on the particular industry, you may have in a B2B context, your customers, which are putting very onerous requirements on you for notification on a very tight timeline. My experience is that in a real incident, most companies are saying, look, we get it. We have some of these very quick turnarounds. You're maybe identifying your list of top VIP clients that you want white glove handling with and going out to notify them. And the other ones are typically, just because it's a massive crisis that everyone's trying to deal with, you're typically then tranching your list of customers so that even you take, okay, we have a 5-day notification time period, or we have a 24, we have immediate notification requirement. It may be that you're saying we're just going to have to get to this group in 5 days, 10 days, whatever the case may be, as we work through our notification regime. And then there's always the issue of voluntary notice, which I talk about as well. And there are pros and cons to that. And it's that transparent culture that Jamie was talking about earlier, where some clients want to pick up the phone. And I think you have to expect that there will be a ton of questions coming back to you asking for, was my data impacted? I need a certification of which of my customers, if I have downstream, it's a B2B, who's that customer has customers that they may have to notify down the line. And so very quickly your team can be inundated with questions and concerns and want the white glove treatment. And so being able to manage that in a complex crisis environment is why we hire people like Jamie and her team to come in and help us support us through that process.
All right, that's great. That's fantastic. So let's move on to retaining a negotiator. So Dan, the client calls and within 12 hours has identified a ransom note. It mentions data exfiltration, and the client is busy working through and thinks it can rebuild or restore or recover from the ransomware case. And they have the policy against, paying criminals, and wouldn't even understand why they would want to talk with the criminal or interact with the criminal. How do you counsel them at that point?
Yeah, this comes up quite a bit, right? And in many cases, either we'll work with a client that may have that policy that says, look, we just don't pay criminals, we don't pay ransom, we're threat actors, or there's no policy at all in many cases. And that's usually the case, right? There is no precedence for this. So the question then becomes, well, who's making this sort of decision? Is this, ultimately whether or not we're going to pay or even open negotiations with the threat actor? Whose call is that to make with an organization? But ordinarily, what I'll tell clients is, unless there is a prohibition on communicating with the threat actor based upon the fact that the group is on a sanctions list and we can't speak to that at all, and if there is an actual threat of exfiltration, there is little downside in at least opening a dialogue to gaining some more information about what the threat actor at least claims to have taken. And at that point, again, we can do a little bit of an intel and investigation based upon what we know about the threat actor, because as I mentioned before, right, they're usually very good about advertising who they are and promoting themselves to figure out, does this threat actor typically take information and data? Do they typically post that information if the ransom isn't made? In some cases, even though threat actors will claim to publish the data, if payment isn't made, it doesn't always happen that way. So getting that information up front is really important. But let's say we're now in those conversations with the client. The client says, well, okay, fine. I don't necessarily want to make a payment. I don't like the idea. It makes me feel like I need to take a shower, the idea of even having to pay a criminal. But I'm willing to explore that option of doing so. Once we've had at least that dialogue, and now we've determined that we want to move forward with communicating, I try to make the decision of whether to pay versus no pay a very data-driven decision. And the idea of paying a criminal is typically a subjective philosophical one. And we don't have a lot of data to make or to drive the decision of whether we're going to pay or not. So I try to turn it into more of an objective type of analysis. And usually what I'll do is I'll say, let's figure out, based on a few different criteria points, number one, what is the timeline if we don't pay to restore from our backup? How much time is that going to take versus the time it's going to take to decrypt the data if we do pay the threat actor and get a decryption key? Okay, so now we've got a timeline to compare against. What's the estimated cost? If we don't pay, how much revenue are we losing until we can restore our data? Versus paying, now we can figure, well, what's the ransom payment looking like? What are we comfortable, in quotes, paying, plus the lost revenue that we're going to experience until we restore the systems? And we can balance those costs out. If we do pay, there's a risk that when we get the decryption key, right, there may be some corruption of our data when we go through the decryption process. So there's a risk there versus restoring from backups and not paying. Are we going to have an incomplete restoration? Are we going to have gaps in the backups that we have? Are we going to miss a certain number of days? So we can weigh those risks as well. And then, are we going to have reputational harm? If we decide to pay and that information gets out, does that impact us? Do we, look unfavorably with our employees, with our customers? Is that something that's going to maybe hurt us in the public eye versus not paying and the data that gets stolen is now public. Right. So now we can build sort of a table here and identifying these pros and cons.
Yeah. And I know they're going to cover that ransom, pay, not pay later on. And I would just also add for all the clients when we counsel them that why would I ever want to reach out to the threat actor? Well, if you don't, then they're not just going to walk away. They can start contacting your executives, your partners. They can do DDoS attacks. They're very, very persistent. So you just can't not contact them. And if you contact them, you have all kinds of upside. You can see what they're going to tell you what they have. They're going to give you a sample to some extent. And it's a delay tactic, right? Because you need to figure out what's going on in your systems and your notification, your communications, your legal obligations. And the last thing you want is all that to be preempted by a criminal not hearing from you and deciding to publish your data somewhere.
And Kim, you can even talk to sanctioned persons, right? It's only facilitating the payment to sanctioned persons. That's what's prohibited. So I still think you can reach, even if you know you're dealing with a sanctioned entity and you'd never actually pay, still getting that intel can be so valuable, especially if your logs are not sufficient to tell you exactly which data may have been taken. Being able to even procure a file listing or directory can be a very, very valuable piece of intel that can help the investigation really zero in on what may have been impacted. And again, that's really what your then potential regulatory obligations might flow from. Once you're able to piece together all the available evidence to say, it's this database, it's this data set, it's these files, and then evaluating what personal information or what data may be in there that could trigger a notification obligation is typically the process that we're following.
And you can also negotiate with criminals if you have no intention of paying. A lot of clients like, well, I can't negotiate because we really don't want to pay. You can negotiate all the way and just not pay them. There's no,
right.
So,
and there's really
systems, buying time.
Yeah, exactly right. And there really is benefit in hiring a negotiating firm to do this for you. I've seen some clients that have taken it upon themselves, but the benefit of having a negotiator that knows who these threat actors are. They know how they communicate. They know how quickly they communicate. You may not hear back for 24, 48 hours or even more. The tone that's used, the type of style of communication that these negotiation firms use, is really, really helpful versus trying to do it yourself.
So let's go around the table. Jamie, to start, we have just a minute left to say, one practical tip or one thing you want companies to know as they, in the first 24, 48 hours, how to proceed.
Sure. I would, again, underscore the critical step of having a process in place for collecting, escalating, and responding to stakeholder inquiries, not just customers, but employees, vendors, partners. You're going to be inundated as a company in those first 24 or 48 hours, and you might have a very small communications team. So how are you going to set up a system that you're making sure you're tracking what everybody's asking you, who you've responded to, that you have a process in place for drafting the response, getting it approved internally and externally. So having those systems in place ahead of time is so critical.
That's great. And Heather, and I realized that actually we have a few more minutes than I thought. I thought we were done at 9:50. We have 8 more minutes. So please go ahead with your thoughts on, practical tips and how companies can prepare and how they need to think about the first 24 and 48 hours.
Yeah, and I think it's really understanding who the team is, right? And making sure you line up in advance and everyone knows their role and then executes on their role. It's like, doing your job. Know what your job is and then do your job. And then that's what you build your tabletop program to practice in advance. Look, things are going to happen during the crisis. They're going to throw you for a loop. But I think the more you can be calm in that center of the storm and know that these things are going to come at you quickly, don't be so quick to pull the trigger. Don't be so quick to pull the trigger on notifications, and make sure that you're really examining the facts, really understand the evidence and what does the evidence show. As a lawyer, I get told a lot of things a lot of times by people who are just sort of throwing things at me. And it's like, okay, wait a minute. I have to step back, peel back the layers of the onions, cross-examine a lot of the different witnesses. Okay, so tell me, help me understand this. And because if I don't understand, a regulator is not going to understand. And so I want to make sure that I understand what the facts are so that I can advise accordingly. The other big mistake that I see companies make, and it's related to comms, is that I read these notification letters all the time. And it's hard when you draft notice letters or a communication that's going out to all employees or a communication that's going to your customers. When you're in the middle of a crisis and moving very quickly, sometimes it can be easy just to scan a letter and say, okay, looks good, let's send it. it's so important to have at least one, maybe two. And I really honed, I think, the skill over the years to read every single line so carefully to make sure, is it honest? Is it true? Is it factually correct? Do we have the evidence to support what we're saying? Because if at any point the answer is no, you need to fix that sentence, because that's going to come back to haunt you. I read so many of these notification letters that say your information may have been impacted, when actually it turns out they knew your information was impacted. They just said maybe. And that's wishy-washy. Those are the kinds of things that have been come back to haunt companies. So really taking the time before you're hitting send on any communication or finalizing a letter to very carefully read it. And my associates on my team will tell you that I'm brutal on these things of really slashing and burning the text. But I read every single thing before it goes out the door, because that's what can lead to the risk of further liability, whether from a regulator or class action litigation or otherwise. So maybe that's one area, Kim, that we haven't talked about quite as much, as the risk of liability that flows from the actions that you're taking in the immediate aftermath. Is there a panel on that later today? I forget. Maybe.
I forgot as well, but
okay.
I do the same. The only other thing I add is I make my associates read it out loud, because it's so hard when you see the same language recycled over and over, but there are nuances and changes. So reading it out loud sometimes can catch some of those. It's tough. It's really tough.
Yeah, and just to add one thing that Heather said is with the messaging is having caveats, right? So that's where I think companies get in trouble. They want to make definitive statements right away. Maybe in the first 48 hours of the forensic investigation, there currently is not evidence of data exfil, but as we all know, most ransomware cases end up that way. So making sure we're saying things like the investigation is ongoing, but to date, we have no indication of X, Y, and Z, because having those definitive statements that you have to later correct is just going to erode trust and be a bad look.
Totally.
Perfect. Dan?
Oh, go ahead, Dan.
Sorry, go ahead.
I was going to say one thing we didn't talk about was law enforcement. So I don't know if Dan wants to bring up that, or I'm happy to throw in a few ideas. And reaching out to law enforcement is one group we haven't talked about in the immediate aftermath of receiving that report.
Yeah, go for it, Heather. Yeah.
So I would just say every circumstance presents itself differently, and that typically having a relationship in advance at the headquarter level of the company in the local region, finding typically we're working with the FBI. In some cases, we're going to make a report through the IC3 database for purposes. The facts can be very different. You don't always need to be working directly with law enforcement immediately. In some cases, you may be going to law enforcement after you resolve the incident with your list of indicators of compromise, but because you want to add to the profile, you want to build that relationship and give them the information that they need. However, if there is an interest in making a payment, then of course, pursuant to the OFAC, FinCEN guidance, you may think you're dealing with a non-sanctioned entity, so you make your payment. It turns out later it was a sanctioned entity. The guidance is very clear that Treasury will view your cooperation and consultation with law enforcement before making the payment as, I don't want to call it a defense, but a mitigating factor in that violation. And so if you think that there's a potential you may be making that payment, reaching out to law enforcement in advance, establishing that relationship, sharing information about what's happened, but carefully doing that through counsel, because Kim, to your point earlier, it's a third party, right? So you want to be very careful that you're not waiving privilege. We have a lot of our technical folks who will say, I'm former FBI, I've got these great contacts, they're very quick to reach out. The challenge with that is that it can waive privilege of the investigation, so you want to very carefully manage that.
Yeah, and maybe what I would add in sort of closing is we've talked about a lot of topics, and there's a lot that the company needs to consider. But from my perspective, if you can come in, if you can calm everyone down, get the structure set up to protect the company in the first 24, 48 hours, which usually is in hiring and engaging experts to start advising, and just stay focused. Regulatory obligations will come, law enforcement will come, third-party intermediary. You can start to identify those as issues, but telling the company to take a big breath, got a long haul in front of us. The most important is to get the structure in place, get the right advisors to take the right steps, and be able to have thoughtful and informed discussions about those decisions is often the most important to sort of lower the temperature. Dan, any final thoughts?
I think just one final thought, all great points, is what I will always tell clients from a proactive perspective before this issue ever comes up is to know your data, know what you've got, know what you're storing, know who has it. I don't know how many times I've worked with clients who've been hit by ransomware, and you will figure out the systems that have been impacted, and the questions will be, well, what sort of data is on there? Do you have anything that's sensitive? Do you have any HR or the financial related data? No, we don't store any of that. That's all kept separate. Only to find out later that you've had a handful of employees that stored, tons of this sort of data on their local machines or on their local file shares. Happens all the time. And that information ends up being compromised. And now we've got to backtrack. And now we have to analyze what our obligations are based upon that. So the real takeaway is take the time to really analyze what you got, what your employees are doing with their data, what type of data, and that'll put you in a much better position. If, the bad day comes where it's compromised, we have an inventory, we know what's at stake.
An ounce of prevention is a pound of cure, right?
For sure.
Yeah. Okay, Bruce, I see you pop up. I think our time is out here. I really want to thank our expert panelists today for a lively discussion on what to think about in that first phone call.
Same, and thank you, Kim, for skillfully starting us off today. Really appreciate it. Dan, Jamie, Heather, Kim, thank you so much for a great start to the day, and we'll be back at 10:05 with our next panel, which is a OFAC focused panel. Thank you.